No, I'm good. The sad thing is, I woke up at about 10 this morning, looked at the alarm, said, yeah, I got time. Rolled over, went back to sleep. Woke up again, but what is it? It is 1:30. I was supposed to be somewhere. Good morning. Good morning. It's not morning. I am Boozy Badger. Welcome to Boozy's Basic Law. What is this panel? It's very simple. We're going to talk about basic legal concepts, maybe not so basic legal concepts. We're going to do that in the Socratic Method. Do you know what the Socratic Method is? Talking.
Isn't that a method of reasoning?
You say method of reasoning, what do you mean?
Method of logical thinking.
And how would that method work?
Well, it's a dialogue.
Asking questions.
Philosophical concept.
I'm going to say whatever he said, because he sounded smarter than me.
Why do you think he's smarter than you?
Good example.
Because he had a lot more words than I do at this time of day, and I'm probably about as functional as you are right now.
Does the usage of more words necessarily imply greater intelligence? Anybody can get more words by having a dictionary.
I am guessing that the Socratic Method has to do with the Greek philosopher Socrates, who came up with a logical way of applying philosophy to the world sometime in ancient Greece.
But how would Socrates make people believe in that logic? Logic and understanding it. That is the Socratic Method.
He kept asking questions and trying.
Socrates would ask questions as to whatever statement you had made. How did that come into play in law schools? At Harvard Law, there is a library called the Widener Library. There's a book for lawyers out there. It's called 1L. It's about your first year at law school. It's written by a guy who went to Harvard. Dean Widener developed the Socratic Method for law school. To this day, when you are getting a tour of the Harvard Law campus, they will say, there is the Widener Law Library. He is the developer of the Socratic Method for teaching law. And if you have someone who has enjoyed their time in law school, they will then say, may he rot in hell. Oh no, I'm fine. I just dumped my head under the sink and ran.
How about a beer instead?
So, that is the way we teach this panel. That's the way we do this panel. We talk about a concept of law, I ask questions of you, pose them to you during that time period, and then I see how you answer. And I ask a question about your answer, and then you respond. Why? Because we're going to give you a crash course in one basic legal concept, be it civil or criminal, during today's panel. Who knows what the basis of the American legal system is? Yes?
Innocent until proven guilty.
No. Yes? A corrupt one? Right. I said the basis, not the end result.
Is it the Codex Justinianus?
The Codex Justinianus. What is the Codex Justinianus?
The Codex Justinianus is Justinian, or is Emperor Justinian, or more accurately, his lawyer Trebonian's attempt to codify some 500 years of Roman legal decisions down into a concise collection of books.
Roman legal decisions. Are we a Roman law system?
I'm not saying we are, I think we are based on it.
Are we?
I thought we were.
Constitution.
What country would have been the basis of our laws logically when the United States was founded? England. So, did England's laws follow the basis of Roman law? Small history lesson, very quickly. No. They had some pieces of Roman law in there. Everybody in Europe did. However, England during the Middle Ages, like most European nations during the Middle Ages, just kind of did away with a bunch of the Roman stuff, with the exception of the Catholic Church. You're never getting rid of the Catholic Church. English law was a combination of what they call ecclesiastical law and the common law for a long period of time. The ecclesiastical law is church law. Those were the ecclesiastical courts, the members of the church, marriages, divorces, family matters, sometimes matters of inheritance. That was church law, ecclesiastical law. Common law was everything else. That was the civil law. The way that the law developed in that period of time was how? Porn? Did somebody say porn? Let me ask you, who knows how a lawsuit works?
I think someone has to like follow the system that that also to that person, you can serve.
You file a complaint, they're made aware of the complaint. What do they do when they're made aware of the complaint? Do they just say, oh look, toilet paper, and walk off into the night? No, they respond. They do something, right? They answer, they file a response. And how do they decide it? Do they flip a coin? Play tiddlywinks?
Maybe. Rock, paper, scissors?
Yeah, rock, paper, scissors, yeah. Oh crap, I guess we're divorced.
That'd be so much easier.
Judges, courtrooms, that's who's making those decisions, right? So in the absence of a code of law that is written down, who's making the decisions? Who's determining what's legal, what isn't legal? Who's the government? The government's your legislation. The government's the people in charge, right? The big boys. Judges will make that decision. And for a long period of time, that's how law was made. Two people would show up in front of a judge with a legal matter. A judge would say, yeah, this seems right, and render a decision, and the two people would wander out. That went into judicially created law, what we know now as the common law. It is law based on precedent and a series of decisions. What's the difference between the common law and statutory law? Statutory law is written down. It's written down, it's made part of the law by a legislature. So, when we came over, when they started this experiment, this failed nightmare, this Frankenstein of a country, what did the English settlers apply? They applied the legal system they were already operating on in Great Britain, in England, known as the English common law. Don't know why we use it like that still with that much importance, the English common law. Because there's only one type of common law now. Everybody else, every other country that had the common law system went to codified law, statutory law. But we refer to it as the English common law, and that is the basis of the legal system in the United States, is the English common law. As a matter of fact, there was one of the few decisions made almost immediately by the first Congress after the formation of the Constitution was, all those legal decisions from England, there are legal decisions too now. So that we wouldn't have to rewrite the common law system, and it is developed overdone. Understanding that, none of you understand that. Understanding that, you can see how I can say the common law has been around for hundreds of thousands of years, and why it is not based off of Roman law. It is not based off of Roman law because the English didn't base their system, except very mildly, off of Roman law. And we just kind of wholesale stole the English judicial system and planted it over us. With one distinction, we don't have barristers. Does anybody know what a barrister is?
Versus an attorney?
I'm going off to the side here because it does not apply in U.S. law whatsoever, but it angers me. It makes me angry that we don't have barristers. The reason it angers me, there are two types of lawyers in what we call the bifurcated representational system. There is a solicitor and there is a barrister. A solicitor sounds like somebody who gets charged with solicitation, and I've known a few attorneys that description meets very well. But a solicitor is kind of like your low-level lawyer. They don't appear in front of the higher courts or things like that in those systems. However, they can do wills, they can do estates, they can appear for minor legal matters. things like that. They are not the big trial lawyers that go up in front of the major bench. A barrister is. A barrister is primarily a trial attorney. That's basically what they do. They appear in front of what they call the Queen's Court. The Queen's Court being the trial courts of Great Britain. You all have seen the image of the English lawyer. What do they wear?
A powdered wig and a black robe.
A wig and a robe, and those are barristers. Solicitors do not have wigs and robes. A major difference between it used to be a barrister would not directly interact with their clients. The solicitor would find the client, retain the barrister, brief the case to the barrister, and the barrister would very rarely speak to their client. Their job was to present the case to the court. We don't do that in the U.S. Every attorney in the U.S. is both a solicitor and a barrister. We are attorneys at law. We handle just about everything. We do retain the idea of a minor judiciary and a major judiciary. Who knows what a minor judiciary is? Yes?
Small claims court?
Say what?
Small claims court?
Is that all it is? Small claims court?
Arbitration?
Is arbitration even judiciary?
I don't know. Mediation?
Mediation?
I don't know.
Yeah, there we go. You see that?
Okay,
I don't know. Play along! No, but no. Small claims court is an example of minor judiciary. Yes. Arbitration and mediation, not so much. What is arbitration?
Oh, great. I thought that's another rabbit hole.
It's a short rabbit hole, though. It was a rabbit hole dug. It was a rabbit hole dug by like a rabbit with only one front paw. What is arbitration?
Communication between two parties and the neutral third party.
Is that arbitration?
A third party decides some sort of, for example, payment.
Isn't that court though? Like the judge is a third party in your dispute.
Without a jury.
Without a jury, well, that brings up, does everything in court have to have a jury?
No.
Are you entitled to a jury for most things?
No.
Yes. Yeah, I'm not even going to play around with that one. Yes, you are. For almost all criminal matters, and I say almost all because some jurisdictions have been like, oh, this is a traffic offense. Screw you, you don't get a jury.
Right.
And the vast majority of civil matters, you are entitled to trial by jury. However, do you have to have a trial by jury?
No.
So who decides that?
The judge themselves.
The judge themselves, right. That's what I say for anything with jury. Now, the judge, though, the judge is a third party, right? So can a judge not mediate the dispute? Can a judge not sit both of you down in the courtroom and say, this is ridiculous, have you two talked?
Yes, they can.
Of course they can. But that's still a court hearing. It's not a mediation. The difference is simple. A mediation is, as we said, a neutral third party sitting there trying to get you to reach an agreement, but they're not a judicial officer. They're not a judge. Same thing with an arbitration. An arbitrator may have been a judge. Vast number of arbitrators are retired judges. But an arbitration is almost like a little legal proceeding. And you do it without a judge, without a jury, without the formalities, under different types of rules. Is a formal but informal process that's not impacting the judiciary. That person then comes to a decision, they issue an arbitration award, and if it is what we call a binding arbitration, there is something called the Federal Arbitration Act. Most states have a version of it that then lets you take that arbitration award, put it into court, and make it an enforceable order of the court, at which point it becomes a judicial matter. So arbitrators and mediators are not necessarily judiciary, and they're not judicial officers while they are acting in those roles. So what is the minor judiciary? Who's heard the term district court? Who's heard the term district court for their state? You have purple and black on your arm. What is the district court?
It is the major court for a large region of the area.
Major court? For your state?
I don't know. All I know is that I have one in my city.
There you go. The district court is your minor court in most places. What is the minor court? There are levels of courts. Okay, you obviously know the Supreme Court. You know the Court of Appeals, all that, correct?
Yeah.
All right. Even when you come down to your local and your county courts, you have levels of court. Where I am, where I practice law in Pennsylvania, we have the magisterial district judge, and then we have the Court of Common Pleas. The magisterial district judge is what we call our minor judiciary. In Pennsylvania, they don't even have to be lawyers to be elected judge. Like Steve the mechanic can be elected to the magistrate's court. Now, Steve the mechanic then takes like a 4-week boot camp on how to be a judge, and then they give Steve a courtroom and a robe. But what does that judge handle? They handle small matters. They handle summary traffic offenses. They handle terms of imprisonment of less than 1 year. In Pennsylvania, they handle civil actions. Who knows what civil action is?
Would that be a lawsuit between two individuals?
A lawsuit between two individuals, correct. What's the difference between a civil action and a criminal action?
A civil action is two people have a disagreement. A criminal action is when you break the law.
Well, that's actually a really good way to put it, except you can break the law civilly. Like, it's not everything that breaks the law is necessarily legal. Yes?
In criminal, the prosecutor, which would be the state, charges you. In civil, it's between two entities that are.
That's a good distinction right there. You said the prosecutor charges you. Is anybody charged with anything in a civil action?
Nope.
No. And that's a good summary. I would say that's what we could call a good layman's summary, but there is one exception. I'm a government lawyer now. I don't prosecute people. I now am going to be representing one of Pennsylvania's executive agencies. And in the course of doing that, I'm going to file lawsuits against people. I'm not going to be prosecuting them. They haven't committed a crime. And that's the difference. A criminal action is for a violation of the criminal code of the jurisdiction in which you're in, and it's an action brought by the state. A civil action is money. You've done something unlawful. I want a divorce. Grandma died, and we can't agree who's going to get what under her will. Those are all civil actions. An easy way to put it, and the easiest way to put it is, if it's not civil, or if it's not criminal, it's a civil matter. So back to the idea of the minor judiciary. These are judges that handle small claims, like you just said. They handle traffic tickets. They handle, in my jurisdiction, landlord-tenant matters. Then we have the major judiciary. The major judiciary is your trial court. We call them the lowest court of record. The major judiciary, everybody in my state is the Court of Common Pleas. Everybody on those courts are the judges. They are the people you think of as the judges. Former lawyers, ran for the bench, got elected, served for years, big fancy courtroom. Or as I'll tell my clients, and I deny, and every time I tell them this, I say I will deny this to my dying day if you repeat it. This is big boy court. This is where we have a jury. This is where we have a trial. This is where we have months of motions, practice, and arguments. That's your difference between major and minor judiciary. Have I left any part of it uncovered? Not that I can think of. All right.
I know you're the lawyer.
Yeah. Well, ostensibly, yes. I also woke up 20 minutes ago. By the way, that is the quickest I've come barreling into a period of time.
Did you for a moment think, oh shit, I'm late for court?
No. No, I did not. As a matter of fact, on the way down here, I was going to come in, sit down, and go, you all just learned a valuable lesson. I'm on time. You all are just early. That is something, I had a professor in law school who would teach you that lesson by waiting to like 10, 15, 20 minutes one day class before coming in and starting the class. When we'd say something, he'd say, here's a valuable lesson for you. You take it into practice. The judge is never early and the judge is never late. You are either early or you are late. The judge is on time. That said, recognizing that we are the basis that we come from, the English common law system, let me ask, how many states do we have that follow the English common law?
49.
49. Somewhat 50, but 49. What's the one that doesn't?
Louisiana.
Louisiana. What type of legal system does Louisiana follow?
French common law?
The Napoleonic Civil Code. It's actually kind of a hybrid. They follow a little bit of both now. But Louisiana retained portions of the Napoleonic Civil Code Act of Louisiana Purchase. into their law still use it, and you hear lawyers who are not from Louisiana say on a regular basis, fuck that. I am not going to Louisiana. So, we have that general overview. Now let me ask, how many of you have been involved in a lawsuit? Are any of you presently involved in a lawsuit? Don't raise your hand. The people who are involved in a lawsuit, who are those again? Who doesn't mind telling us what their suit's about? Yes, right back there.
We had to sue our own insurance for a car accident.
You had to sue your own insurance for your... I like you. So let me ask, why would somebody sue their own insurance for their accident?
They
broke the terms of their own agreement.
They broke the terms of their own agreement? Can you think of any other reasons?
The insurance is being an asshole and not paying up.
The insurance being an asshole, not paying up. Can you think of any other reasons?
There is a discrepancy in payment to where you know you paid insurance claims you didn't, and they cut your coverage because of that.
All those are great answers, and they're all accurate, by the way. It's the most common lawsuit that you see with insurance companies is, I'm assuming in your case, either they didn't pay, or they paid too little, or they said it was excluded.
Paid too little.
Paid too little. Those are the most common ones that you'll bring against an insurance company. Can you sue yourself?
Yes.
Yeah.
Why would you sue yourself?
Because you're an asshole.
Yeah, I like, can you sue yourself? Why? Yes, why? It's a new form of sadism.
Sadism or masochism?
Yeah, masochism, thank you.
Yeah.
It could be both.
Yeah,
At the same time.
Yeah. I mean, if you like inflicting pain on yourself and you like receiving lays, we would fit both.
You just love doing therapy.
That'd be great. Just from an attorney's standpoint, that'd be great. Who's your client? Tom? Who's he suing? Himself? Who's their lawyer? Steve? Is he paying both of you? Yes.
How would like if the result of that was like money, would he just pay himself?
Well, and that's actually going into that. Why would you sue yourself? If that was the circumstance, why would you? Yes.
Yourself as an individual suing yourself as a corporation.
Well, that's one way. That's one way to get to it. Does that really matter most of the time if you are suing yourself as an individual and you also are a corporate entity? What is a corporate entity?
Person.
It is a legal person. That's right. What types of corporate entities are there?
S Corp, C Corp, sole proprietorship, LLC.
Is a sole proprietorship a type of corporate entity?
I guess technically not.
No. I can't speak for every single jurisdiction. I can tell you the majority rule. The sole proprietorship is actually the default form of doing business when you don't have a corporation. When you don't have a company form. And also, who's responsible for everything in sole proprietorship? You. All debts, all claims. There is no, it doesn't matter if you say, I'm Bob's House of Silicone. Bob's House of Silicone gets sued and it's a form of corporate entity. Bob's the one responsible for paying everything. A corporate entity, when it forms, is formed to set up kind of a buffer because they are, as was pointed out in the front row, a separate legal entity from the owner. The most common type that you'll see, especially for small businesses, is an LLC, a limited liability company. Most of the time, when you have an LLC, what you're looking at is a single-member LLC. The whole reason they exist, even with pass-through taxation. Does anybody know what pass-through taxation is? What do you think it is? Just for me,
It's where you effectively have all of your money going through the corporation. You pay yourself through the corporation to mitigate taxes personally versus what the corporation runs.
Let me ask, we keep saying corporation. Is an LLC a corporation? I just told you what it stands for.
Yes, it is.
No! Limited liability company. Believe it or not, there's a legal distinction. A corporation is a formed entity that is entirely separate from you 100%, normally with shareholders, articles of corporations, and ownership interests that have been entered with special formation procedures by the state. Because of that, they are a much more formal way of operating and operating under much more formal rules. They are also taxed 100% separately from you. If you own a corporation, even if you own 100% of the stock, The corporation is taxed. You receive money from the corporation. You are taxed on that money. It is 100% a separate entity from you. An LLC, that is not the case. Pass-through taxation means it doesn't have to be taxed at the company level. The LLC does not have to be taxed separate from you. Its profits and its losses can be passed through 100% to you individually. Everything is taken on your taxes. It's actually a much more favorable tax scheme. Whew. I've had given that talk to more than one client. So, if you're suing the LLC because you own the LLC and you want the LLC to pay, but you're the sole member of the LLC, what's actually stopping you from paying for it out of the LLC?
Nothing.
Nothing. Nothing at all. Or why would you do something like that? Why would you? And if you're suing the LLC, are you really suing yourself? No, why?
Because you're suing the LLC.
The LLC is a separate legal entity from you. That's the whole reason they exist. So you're not suing yourself, you're suing the LLC. Alright, so, why would you sue yourself?
Create a legal documentation or a record of a transaction.
It is much simpler. Yes, go ahead.
Money laundering?
Courts are famously big on assisting with that. It's actually a lot simpler, and the answer was given at the very beginning. Insurance. You sue yourself so your insurance will pay. The insurance won't pay out if there's not a claim. Has this ever happened? Has somebody ever sued themselves so insurance will pay?
Probably.
Utah. A lady in Utah was driving a car. Her husband was in the car. An accident was caused. Her husband was unfortunately killed. She sued herself in her capacity as a beneficiary under her husband's will for wrongful death, so that her insurance would have to pay. And it worked. The insurance company appealed it. It went up on appeals, and the appellate court said, there's absolutely nothing stopping her from suing you for wrongful death as the beneficiary of her husband's estate, suing herself as the driver of the vehicle. You've got to pay. Yeah. When you hear about my aunt sued my dad, but everybody's fine and they're happy, why would that be? Like, say somebody comes to your house, they get injured. They file a lawsuit. Exactly. When you see those things, that's what you hear. You hear about them saying, oh no, it wasn't a big deal. We had to sue because insurance needed to pay for that. And insurance wouldn't pay unless I was sued. Why? Who do you sue when you're suing somebody's insurance?
You're suing the person.
You sue the insured. The person is the insured party. The insurance isn't the one saying, we'll give you money. The insured's the one who has to be ordered to give you the money. And the insurance company has a policy with them saying, we will pay if they owe you money for this. So you sue the person, and it's not uncommon for people to come together. Let me ask. It's a fun one, and it's a recent one. Let's say you meet someone at this convention. You go out, and they may be in the parking lot. You get to know each other in the back of the car. Let's say several months later, they discover they have herpes. Can they sue you?
Yes.
No, if you don't have herpes.
I hear a lot of yeses. Why do you think yes?
In theory, yeah. But they know who they're suing to begin with.
If somehow they're the only person you've had intercourse with, then I feel like it would work, but also how would you have that?
What if it was consensual? You can sue anyone for anything at any point in time. It just doesn't matter what they don't.
That's a wonderful point. You can sue anyone for anything at any point in time. You're 100% correct. When everybody says, can I be sued? I often say, yeah, you can. But how? I'm like, oh, no. There's no legal precedent allowing this to happen. I'm just letting you know, yes, they can sue you. The question isn't can they sue you, the question is will they be successful. I heard right over here from Mama T, but they consented. Why would that matter?
Well, I'm thinking about my answer now, and I'm saying, well, maybe they consented, but if they didn't know that you had the illness.
Yeah.
Does that matter?
Yeah, if you consent to it, but you don't consent to the potential transfer of charges if you weren't aware.
Does that matter?
Yes.
Yeah.
When a lawyer asks a question like, does that matter 2-3 times, tip you off. Why wouldn't it? Why wouldn't it matter? At law, why wouldn't it matter?
Isn't it like your responsibility when you make any transaction to do your own due diligence? If you buy a business that's failing and you want to do a financial record, it's up to you.
That's wonderful. You actually, like you took what we call a tort concept, because everybody, you all know what torts are, right? Torts are injury claims. Injury to person or property. You took a tort defense concept and boiled it into a contractual defense concept. That's amazing. By the way, if your sex life involves breach of contract actions, congratulations, you're a prostitute. I say that and I don't care how you make your money. It doesn't impact me. It's a nice law. The fact of the matter, though, is you're on the right track. At law, we have a defense, especially to tort actions, which is really what we'd be talking about here. In the case of an unwanted STD, we'd be talking about a tort action. We'd be talking about personal injury action. A defense is called the assumption of risk. Who knows what the assumption of risk means? Yes?
I think that the assumption of risk means that, I'm going to give an example. If you go skydiving, you are assuming the risk that something could go wrong and your parachute is not going to open.
Right. Now does that mean if somebody comes in and before you get on the plane, the instructor looks at you and, fuck this guy in particular, pulls out a knife, opens it up, puts a giant slash in the parachute, repacks it, gets in there, you open, the parachute opens, giant slash, no air, and you're like Wile E. Coyote. Does that mean you can't sue them? You've assumed the risk by getting in the plane?
No, because somebody's external actions deliberately caused the accident.
Deliberation, there you go. It's not something that you could expect to occur in the normal course. It is something that was caused, and that had everything operated as it was supposed to be, would not have happened. Without the interference that everything operated as supposed to be, would not have happened, would not be expected to happen. You see a lot of that in high school sports claims. Where somebody said, oh, my son got a concussion, I'm going to sue the school district. The school district says your son signed up to play football. That is assumption of risk. Yeah, and then, okay, he signed up to play football, but your coach ran him over with a four-wheeler. Okay, that wasn't within the scope of the risk you assumed. We'll let that one go. Why do STD actions typically fail in civil law in the vast majority of districts?
I believe the only one that we disclose is HIV.
Is that even technically necessary?
I thought it was at one point.
Some states, and I will say this, you have to be aware of the law of your state. Some states actually do have specific laws regarding HIV. And the specific law, it's never like, you're going to get prosecutors. It is always, every law I've seen like is always intentional infection. Intentional infection with knowledge. Every time with HIV. I will say that is one exception to the general rule, though, because yes, there are states that do have laws specifically about that as long as you meet the elements. Yes?
I was about to say that it was intentional infection from knowledge in this state, Indiana, and it was criminally gross.
Yeah. And several states do have specific laws for that specific situation. Intent to actually kind of, I don't want to say help in that situation because nothing helps in that situation. It helps to show the case. Showing the case means proving the elements. HIV is one of the exceptions on that. However, the long-standing precedent in the majority of states is STDs will not give rise to a civil complaint. Why? You assumed the risk.
You didn't go and find out before you went with this one-night stand whether there was anything else going on so you're stupid.
And whenever I say that to people, I get people who are not happy with me. Like, assume the risk, what the hell, no. And I'm going, no, look, I agree with you. I'm always, however, my job is to tell you what the law says. And the law says in the vast majority of those circumstances that you assume the risk. Like I said, obviously there are exceptions, and there are statutory exceptions as to it. And case law has started to move a little bit. Remember back the hypothetical that started this whole part of the conversation. You meet somebody at this convention. You go out in the parking lot. You have a fun time in the car. They come away with an STD and they want to sue you. Are they likely to succeed? Everybody's shaking their heads, and I'm assuming everybody's saying assumption of risk, right? Yes?
I'm thinking there might be some.
Intentionally misinformed them.
Well, does intent really matter? Because as we talked about back there, I'm assuming with the case you're talking about, it was an HIV infection? Yeah.
So this gentleman was in Vienna and found out he had HIV intentionally.
Yeah. So intentional infection like that, a lot of times is going to go towards HIV, not towards other ones. Does it really matter? But in this case, let's say it doesn't matter. Let's say it doesn't matter whether you knew or not.
I was thinking less intentional infection, more intentional hiding of that risk.
Are those really different things? No. And honestly, I love it because here's the fun thing. Intentionally hiding the risk. There's a legal term for that.
Obfuscation.
Negligent misrepresentation by omission.
I love that.
And misrepresentation does not have to be me saying, my shirt is bright red. I can lie at law by omission. Matter of fact, the definition of misrepresentation is any act or statement or omission to make the same. In circumstances where we should know. But is that really a misrepresentation if I don't say anything? Hey, you didn't ask me.
Well, they did ask.
Say what? Well, if they did ask, now you may ask them. Do you? But then again, here, do you have anything? No. Okay, well, now maybe we're talking fraud or personal injury. The problem is, fraud is easy to allege and hard to prove. Now, how are you going to prove that they said no? That's the first thing. Number two, how are you going to prove that they do? The second thing is if they say yes, you're like, okay, now we're back to assumption of risk, aren't we? like, do you have any STDs? Oh, so many. All right, Daddy. But it's funny you should mention that because you know what negligent misrepresentation are. They are, once again, affirmative defenses to a contract action. We're looking at a tort action. Because in this case, a misrepresentation could negate the assumption of risk. So if they say, oh, they assume the risk, which is an affirmative defense. Affirmative defense is a defense you prove. Okay? And you were able to say, no, they lied to me, so I couldn't assume the risk because I wasn't appropriately informed about the scope of the risk. That can't negate that. Very honestly.
So like if you have a text conversation with someone before you meet up, it's like, hey, you have any STDs? And you're like, no. Could that be evidence that they lied to you in court?
Yeah, it's evidence that they said no.
Yeah.
It's evidence they lied to you. What do you have to lie to somebody? Knowledge. You have to have intent. You have to know you're lying. How are you ever going to prove they lied? And that they didn't just not know. Because that's the difference. So misrepresentation is not an innocent thing. A misrepresentation is either negligent or intentional. I shouldn't say that there is something called an innocent misrepresentation in some areas, but it's specific to real property transactions. So they have to have some type of knowledge, don't they? All right. How are you going to prove they had the knowledge? Yes. If they lied about being tested, then it's misrepresentation right off the bat. And I would say, arguably, that you'd have them directly in the crosshairs for negligent misrepresentation at that point. Because they were asked about something. They knew they hadn't been tested. They said, oh yeah, I'm clean, I just got tested. You didn't just get tested. But how would you ever prove any of this? And that's where you came to the second one, subpoena the records. Yeah. However, that sounds a lot easier. You know what you have to have before you can have a subpoena? A lawsuit. Courts don't just hand out subpoenas. You have to file an action. A subpoena is a court order within an action for the handing over of documents. There are two types of subpoena to appear and testify, and subpoena to just tackle. Who knows the difference between the two?
What were the two?
Subpoena to appear and testify, and a subpoena to just tackle.
Justice Teague is documents only?
Say what?
Isn't Justice Teague documents only?
Documents and things only. That's the difference. If I issue the subpoena to second, what I say is here's the return date. The return date's 20 days from the day of the subpoena. Appear in my office with these things. And I may ask you questions about them. Now, what happens is they give me the things, and I no longer want them to come to my office. I have the things I ask. To appear and testify means I want you to give testimony. And that's how you do it, but you'd have to initiate the action first. And before you can do that, especially in many jurisdictions, before you can issue that subpoena like that for documents and things, you have to do something else. You got to notify the other party that you intend to issue a subpoena so they can object to the subpoena if they wish. So you can see it may be a longer road than you think to get to the point where you can prove that. But could you sue them for personal injury in that circumstance? Could you bring that lawsuit successfully? Yes.
Because you can sue anyone for any reason.
You can sue anything for anyone for any reason. Can you win?
That's hard to do.
That's up to the judge. Depends on the circumstances.
Geico just paid a lady for getting herpes during car sex.
Yes. Yes, they did.
And it was the most wonderful piece of legal machinery I've ever seen in my life. Yep. How does that happen? Read your insurer's policy for your vehicle. It covers any injury caused by your operation or care of the vehicle. Two people met. Two people who met got friendly in the back of the car. The person who owned the car, and we would later find out owned the herpes, had Geico. He saved $15 or more.
So, what happens if you break it in somebody else's car?
Then they would be liable, I would assume. The young lady was diagnosed. The young lady reached out, and he said, yeah, I know, I just found out myself. I'm sorry. They stayed friendly. She sued him. The theory that their lawyer sued under was, this happened in a car under your insured's control and part of the normal operation. Therefore, it is not excluded, and you, Geico, are responsible for my client's personal injuries as a passenger in said vehicle. Geico looked at it and said, we're not going to defend. Why? Insurance companies, many, many times, when you sue a person and they are insured, that lawyer is not that person's lawyer. It is, but it isn't. That is a lawyer hired by the insurance company, because the insurance company, as part of their policy, says we will indemnify, hold harmless, and defend the policyholder. The and defend means the insurance company goes out, gets a lawyer, and gives you a lawyer for the lawsuit if it's under the policy. Geico looked at this and said, we are an automobile insurer. We are not a sex car insurer. We don't believe that this was part of the normal operation of the vehicle. We will not cover this. Therefore, we're not giving you a lawyer. Get your own, sir. You are finding that you have been excluded from policy coverage. We're not hiring a lawyer because the policy doesn't apply. So the guy goes in without a lawyer, and he says, you know what? She's right. I admit liability. 100%. He does this in front of a hearing that everybody is notified. The arbitration award, because it was an arbitration, is entered. It's entered as a final court order. Okay? See, it's all covered together now. Now we're back to arbitrations. It's entered as a final court order, enforceable, and then she seeks to enforce it against Geico. Because there was never a judicial determination that the insurance policy did not apply, and because it was taken to arbitration, Geico never got the chance to argue to the court through either an intervening action or as a party interested in the complaint that they should not have to defend the action, which is an important step. You don't just get to say, we are not liable, and ride off into the sunset. If people keep insisting you are liable, you actually have to get the court to say they're not liable. It's called a declaratory judgment that looks at a document and says, this is what this document means. So the guy who owns the car agrees to the judgment. She gets the judgment. It gets entered as a court order through the arbitration, the state's version of the Federal Arbitration Act. The court lets them enforce it against Geico. Geico comes back in and says, we believe that this should have been excluded from our policy. And the court said, why? And Geico said, well, because it's not within the normal operation of the car. And the court said, are you fucking around? Because backseat loving's been a thing since the 1950s. We kind of think you should take it into account now when writing your policies. And they said, and number two, you had a wonderful time to raise this argument by participating in the action when you were first made aware of it. You did not. Had you come in when they first filed action and said, we would like a declaratory judgment out of this court saying we are not liable to cover this because it's excluded under our policy, we may have heard you. But now we're at the end, and you were given a chance to participate that you refused to take, and the award has been entered. Well, we didn't know that he had agreed to the award. That's not our problem, Geico. You need to pay for the herpes from the car. That is a recent case, and as T-Max here pointed out, almost immediately after the order was entered, you know what Geico did? Revised their auto insurance policies to specifically exclude STDs caught during the operation. And what is that a perfect example of? That is a perfect example of. Does that mean the rules changed? You can't sue for an STD?
No.
No.
You can still sue for an STD.
Does that mean you won't win if you sue for an STD? I mean, it doesn't change that rule. Because what was the operative part of that whole case? Because you heard me say, generally, the majority jurisdiction, the majority rule of all the states, majority rule simply means the vast majority of the states we have out there. Out of 50 states, 25 or more follow this rule. Say, this is a type of harm, generally you will not get damages for it. Generally, you have been presumed to assume the risk if you bring it. You can bring the action, you are likely to fail. In this case, this young lady brought the action, won, and got a good payday. How? Because I'll tell you, the state that she was in was a majority rule state. There are no damages for that type of STD transmission in that state. How did she win? How did she get money for herpes?
Simply because Geico did not care to defend themselves.
More than that. The defendant, the guy who gave it to her,
admitted full liability.
Didn't fight it. A defense is only effective if it is raised. If your right to bring a lawsuit expires under the statute of limitations at 2 years, you sue me 3 years afterwards. I do not raise that. And depending on where you are, when you raise it may matter. You know, in Pennsylvania, we would say, you have to raise it in your response. It has to be raised as a defense. If you don't raise it, you waive it.
If you don't use it, you'll lose it.
Exactly. If I don't raise that, and then down the road I say, well, they filed action 3 years after this, and I say, well, that's beautiful, that's wonderful, that's great, you're right. You should have said that 15 pleadings ago. Because whether they had a legal cause of action or not, it was your job to say they didn't. And you didn't do it at the appropriate time, and I'm not throwing the case at you. So you got to defend on the merits. In this case, she sued for something that had it been a contested action, she likely would not have gotten damages for. However, the person who gave her herpes decided not to defend, and more or less admitted all the elements of fault. And the arbitrators, I can tell you, most arbitrators are retired judges, said, "You're not going to defend this, no. You know, if you say something, yeah, I know. You're not going to defend it, no. Is this an insurance thing? Yeah. Okay. Like, we know what you're doing, by the way. When you do that crap, we know. Like, is this an insurance thing? Yeah, okay. That's how she won. Because the other side didn't put up a fight, which leads to the last part of this. Has anyone here ever been served with a lawsuit of any type and just ignored it?
You don't want to.
You don't want to. Why? Because even if there is absolutely no grounds for the lawsuit, even if there's no grounds for the action, if you go on Reddit, do not give me advice for Reddit. If you go on Reddit and you say, I've been sued for this, are they going to win? And everybody says, no, 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 no. You go, well, if they're not going to win, screw it, and run out the door. If you get served with an actual lawsuit, you can't ignore it, because whether they have a cause of action or not, if you don't respond,
they win.
They win!
You gotta be there to defend yourself.
With that said, are there any questions? Yes?
For the Geico thing, they didn't want to be his lawyer representing him. They said themselves and say, hey, this is them.
Yeah, and as a matter of fact, that's the basis of the holding. That's why the court says you were given an opportunity to participate, because what the court said was, if you wanted to say the policy excludes this, you should have come before us and asked for what we call a declaratory judgment that the policy excludes this. A declaratory judgment is just putting a written document, a contract in front of the court, and having the court say, this is what it means, this is what it doesn't mean onto it. That's actually the reason Geico ended up being held responsible, because when they said, we are not going to defend you, we think it's excluded under policy, and there was some pushback on that, Geico should have asked for a declaratory judgment as to the meaning of that policy provision.
So basically, Geico got lazy.
Yeah.
Geico essentially just did what you said. They saw the lawsuit and walked out the door.
Yeah, they said it's not our problem and left.
And it is your problem once you do that.
So I do not suggest, by the way, that you have unprotected sex with anybody in their car if they have Geico. They've covered that loophole. Allstate, however. Folks, thank you very much for a wonderful.
Silver Gattoman, he bought me a coffee. Silver Gattoman, here is the song for thee. He likes to video all the panels at the cons. You should go and watch them whether they are short or long. Silver Gattoman, you video that's not a jibe. All of you go to his YouTube channel and like and subscribe.